Mohammad Faisal Hayat, and I will try to dive deep into what this arbitration or international arbitration is, right? And as Matthew mentioned, this is just an introductory session. So we are just scratching the surface of what are the available methods of dispute resolution. And I always get confused. I would not say confused, but curious. And that question actually led me to choose arbitration as one of the topic for my final year project. So if you look at the court system, that was actually initiated not so long ago, right? Maybe 1,000 year or maybe 2,000 year, right? But before that, it used to be negotiation, mediation, or even like if you look at the cultural aspect of ADR, Jirka or Panchayat, right? Those were the default method of dispute resolution. But then it came court system, they institutionalize resolving dispute, and then litigation become a default form of dispute resolution, and then they call these arbitration or mediation that used to be a very normal procedure, they call it as an alternative dispute resolution, right? So that's a very curious thing, and I'm actually looking an answer for that, and I hope I will be able to find out. But I will suggest you guys as well, like why we call this an alternative dispute resolution when it's a human instinct that we resolve a lot of dispute through negotiation or in the presence of someone knowledgeable or noble, right? So in my presentation, I will be covering what is international arbitration and why to choose international arbitration, why not simply litigate. We have put a lot of effort to have this institution, which we call court, to resolve dispute, right? Why we are again approaching towards the method that we used to do before, right? With international arbitration, I will go to the definition of arbitration later. But first, we really have to look at what does this word arbitration mean. And there are certain elements that should be present to name or tag a process as an arbitration. Because if you look at other method of dispute resolution, they somehow gives a feeling that this might be an arbitration, right? But if you see, these are the elements that must be present in arbitration, right? So the first one is consensual. It is a consent-based method of dispute resolution. If two parties agree that they want to resolve their dispute through arbitration, then arbitration will come into effect, right? I always give example of national court. So there is two parties, they made a contract and dispute arise. One of the party went to the court, they file a plaint if the party is from Pakistan, or a complaint if the party is from other places, right? Whatever name you want to call it. So they go to the court, file a plaint, and then the court will send notice to the other party that they can come and defend the case, their case, right? Now, the party will not be curious like why this specific court is sending me the notice, right? Of course, they will try to satisfy that the court has the jurisdiction to resolve that dispute. That jurisdiction can be a temporal jurisdiction, whether the subject matter is time barred or not, or maybe a pecuniary jurisdiction. But when it comes to arbitration, party A was from Pakistan and other one was from Germany. And party A on a random, I would say Monday, they receive a notice from London Court of International Arbitration that we have received a notice of arbitration and we request you to submit a response to the notice of arbitration, right? Where that court, where that random, I would not say random, where that specific London Court of International Arbitration send a notice to that specific party, right? So this is where the agreement of the party will take place, that both the parties will agree that they want to resolve their dispute and through this specific institution, right? So this is the cornerstone of arbitration. So the first element should be present. And if we look at the legal framework, we have, as Matthew mentioned, we have New York Convention with respect to the enforcement and recognition of the arbitral award, and not just the arbitral award, but the arbitration agreement as well. It's Article 2 state, and I quote, agreement under which parties undertake to submit to arbitration, right? They are giving their consent that their dispute is going to resolve through arbitration or shall going to resolve to arbitration. And then we have on-suit trial model law. These are, I would say, the model law that the countries can follow to implement that into their national law, so that we can have a very certain and predictable international arbitration legal regime. And it also states that in its Article 8, an agreement by the parties to submit to arbitration all or certain dispute. So they can also say we want to resolve all the disputes through arbitration, or they can also say we want to resolve certain disputes through arbitration, right? And then the next element is private decision maker. And by that, I mean the decision maker should not be a national court judge. If it's a national court judge, then that would not be called an arbitration. That would be a litigation or adjudication by the court, right? So the decision maker should be a non-governmental person, which take me to the next element, which is chosen or on the behalf of the parties. I think John mentioned in the first half of this session that arbitration or any other ADR process, it provides a lot of flexibility. And this flexibility can also be seen that the parties are given the choice that who should be the one to resolve their dispute, right? So the parties have two options. During the formation of their contract or arbitration agreement, they can specifically mention which person should act as an arbitrator during or in case of a dispute, right? Or alternatively, they can select a person after the dispute arises, right? So maybe after the dispute arises, they know the dispute is related to construction, road construction, right? So they can appoint a person who has an expertise in road construction, right? So the parties can choose the arbitrator, or if parties failed, then the arbitral institution that the parties have chosen, that institution can help the party choose an arbitrator from the arbitrator pool that they have. And then in Pakistan, because the domestic law is a very outdated law, which is Arbitration Act of 1940, and at that time the institutions were not that popular. So that's why that act recognized only ad hoc arbitration. So in that act, it provided that if parties fail to appoint an arbitrator, then the court will help the parties to appoint an arbitrator, right? So but in the modern jurisprudence, it's the institutions that usually appoint the arbitrator and not the court, because you have chosen arbitration to avoid courts, right? So it's the institution that help the parties to do that. And the next one is final and binding decision. And I think so far you must have observed that in negotiation or mediation or even in conciliation, the decision is not being imposed on you, right? In negotiation, both the parties are coming on a table and agreeing on one point, or in mediation, they are having an agreement, right? That, but that agreement does not have the same legal value as of arbitral award or even a judgment, right? That's just any ordinary agreement. And if the parties want to enforce that agreement, they have to follow the same procedure that they would follow in case of breach of a contract, right? But the Singapore Mediation Convention is a game changer, which is actually making this intermediate agreement as a special kind of legal instrument. It gives a more value to those related agreements as simple as, right? So arbitration does not actually provide a knowing or advice. I would say it's one type of arbitration and advice arbitration, but they don't need that complex. Just for the sake of this concept, the arbitration does not provide any advisory recommendation. It provides a final and binding award that will be enforced by the court, and right, because we don't really have a concept. I think there are 3 or 4 things going on at the same time. Yeah. So you need to have that impartial process in which both the parties are given the fair opportunity to present their arguments or to submit their evidence, right? And again, it's not an executive order or administrative decision, because in most of the administrative decision, you don't really call the parties and hear their side of story, right? They just give that decision. But in arbitration, we don't really use that, right? We hear both the parties, submit their evidences, and then after, based on those evidences and the pleadings, the arbitral tribunal rendered an award, which is, of course, final and binding on the parties. And the reason why we should go for international arbitration, of course, not we, the parties that are having the dispute, right? And to answer that why, we can do it with 6 E's that are mentioned in Caribon book of international commercial arbitration. And if you guys are not aware of this author, Gary Bourne, I think he is one of the most credible or recognized personality in international commercial arbitration. So these 6 E's are expert, expeditious, efficient, even-handed enforcement, and electronic, right? Now, describing each of these. Expert. So if I will compare it with the national court to just to get an idea why we are using or why we are expert as to say that arbitration should be preferred as a dispute resolution mechanism, right? So, as I said, the parties mostly choose an arbitrator after the dispute arises, right? So after the dispute arises, they will be aware like what kind of dispute they are dealing with. Then they can select a person who is expert in that field. A judge is not does not have a business experience himself, right? But if you select an arbitrator who has that business experience or who has expertise in construction or maybe insurance or in technology, right? In that case, it would be, more feasible for the parties to bring every point or complexity or technical matter to that arbitrator. But if you are going to a national court, then you have to first educate their judge on that specific matter. And most of the time, the court also invite experts who provide opinion on a specific matter that the judge is not aware of. But in arbitration, you are selecting the person who has already that specialized knowledge, right? So that's one of the reason why the party should go for arbitration, because it provide the person who has expertise to deal with that specific dispute. The next is expeditious. As I said earlier, there is no appeal system for the arbitral award because it's final and binding on the parties, right? But there are certain limited judicial review process where the court can analyze whether all the procedure was followed or not, whether that award is contrary to the public policy or not, right? Or if it was arbitrable or not, right? These are the grounds that the court can consider before setting aside that award, right? But if all those requirements are fulfilled, majorly procedural, then the court is not allowed to look into the contents or the merits of the award, right? Because the arbitral tribunal has already decided that, and parties have given their consent for the arbitral tribunal to do so, right? So in that case, there will be no appeal process. Parties will get their award and that award will be enforced. Unlike the national court, I will give example from Pakistan. We have at the very low level, we have a civil court, then district court, high court, and then Supreme Court. So if parties get a decision from a civil court, and if one of the party is not ready to accept that decision, then that party can go and appeal in district court. And then if the other party is not ready to accept that decision, then they can go to the high court and then Supreme Court, right? So according to the survey of Supreme Court, in Pakistan, for a civil case, the average lifespan is 17 years. So I don't think so any party in their right mind will come to Pakistan, spend 17 years to get their dispute resolved if they have an option to go for international arbitration, right? And I think John discussed Italian experiment. I think it happens in other countries as well, in Turkey, and they are also trying to do in Pakistan, but there is no progress in that because we're also having 2.2 million backlog, and we have only 3,400 judges. So I think there is a need for a mandatory mediation in Pakistan as well. And then it saves time on complex technical issues. As I said, the person will be expert. He does not need any education on specific point. And then for the smaller value disputes, for example, if an arbitration institution says if the dispute value is not more than $1 million or pound, then they are going to put this on a fast track procedure, right? That it should get resolved within 1 to 6 months, right? And then again, it will make the process more expeditious as compared to any other method available, right? And then it actually complement the previous the efficient. It provide a very streamlined procedure, and you don't really feel any delay as compared to what you see in a national court, where you have to wait for your case to be heard, right? But in arbitration, it's on the parties, like when and where they want to do their arbitration. And there is a difference between, I think in the subsequent sessions, you will hear that too. There is a difference between seat of arbitration and place of arbitration. So by seat of arbitration, you are choosing a neutral third country whose procedural laws will be applicable on the arbitration proceeding. And by the place is the physical place, or after the COVID, we saw the virtual place can also be a place of arbitration, right? And then there's a tailored process agreed by the parties. Of course, parties have all the freedom to tailor the process, but they need to be very careful when it comes to the institutional rules, because they also don't want to choose a process that is contradictory to those rules, and that can actually give a reason for the other party to challenge that during the enforcement proceedings. The next one is even-handed. And this is with regard to the impartiality of the tribunal. Let's take an example. Again, one party from Kazakhstan, other one is from France, right? No, the Kazakh party will never, in their right mind, would agree to go and have their dispute resolved through the French court, because they know the French court is going to favor their own party, because the French party will be well aware of the rules of the France, right? And similarly, for the French party, they are not going to come to the Kazakh court and get the dispute resolved. So that's why we are finding out a neutral third venue where the parties can go and have that equal opportunity to present their case. So this international arbitration provided even-handed opportunities that provided a neutral, independent, and impartial tribunal, right? And it also avoids concern over the home court advantage, and it's a neutral third form, right? The next one is enforcement. As John and Matthew rightly mentioned, that the foreign judgments are difficult to enforce other jurisdictions, right? But international arbitration, and I think all the credit goes to the New York Convention, that make a very perfect mechanism for the enforcement of the arbitral award. And that's the same convention which also inspire the Singapore Mediation Convention, that if we can have a mechanism for arbitration, we should go for mediation as well, because arbitration, even though we say it's very effective with respect to time, but not to the cost, because now it's becoming more expensive because arbitrators are charging a lot of fee. You have to go to another country to resolve that dispute and all that, right? It's adding up the cost. So this has a very strong enforcement mechanism. We have New York Convention and then national arbitration laws, and those arbitration laws, they are based on the ancestral model law. So that's actually creating a coherence between the laws, of making very predictable and uncertain for the parties to go for the arbitration and resolve their disputes, right? And of course, at the end, if the parties would not be able to enforce that award, then there is no need to go for all that procedure, right? So it's also provide a very effective mechanism for the enforcement. The last one is electronic. And I think there are two aspects to this. The first one is, I think someone in the first session, they asked a question about the online dispute resolution. And there is a firm in United Kingdom, ADR, ODR International, and they are doing a lot of work to promote this online dispute resolution. And one of their argument is also to go for the green arbitration, right? And they are saying we should not be traveling different countries to resolve our dispute if we can resolve a dispute through the comfort of our office, right? Just like we are having this international summer school, we could have, if given the financial means, we could have done it in person as well, right? But that is not very environment friendly. So that's one of their argument, that we should opt for the green arbitration. And then it's continued functioning during the pandemic. If you saw during the COVID era, the courts were shut down, but the arbitration proceeding was still going on, because it's a bit easy for the parties involved to switch to the virtual space, right? But for the courts, it's really actually difficult to update all that system and shift to this technology. I will take question in the last because I don't want to break that momentum. But if you think your question is very crucial or should be answered, then of course you are free to ask. Then there are different types of international arbitration. And by that, I mean, we can divide arbitration with different context or different perspective, right? So if we are seeing this through the lens of a subject of the dispute, right? Then there can be more types as well, but the main types are commercial arbitration, investment arbitration, and construction arbitration. And if we look through the perspective of parties, then we have like three: party versus private party versus private party. That is actually commercial arbitration. Then we have private party versus state party. This is going to be investment arbitration, because private party will be an investor while the state will be a host state for that investment. And then state versus state. So arbitration before the United Nations and all these international institutions or the International Court of Justice, ICJ, the countries usually the disputes through arbitration. So a state versus state, like two sovereign state, can also resolve the disputes through arbitration. And then by administration, there are two types. One, you can go for institutional arbitration, where you will select a arbitral institution that will be dealing with the case management stuff, keeping update with the arbitrator, opposing party, sending them notices and all that, right? And one of the crucial thing that you should remember is the uh, resolution of dispute is not the duty of the arbitral institution. That is very crucial. They are there just to facilitate the arbitration process. To resolve the dispute, it's the duty of the arbitral tribunal, right? So arbitration institution is just there to have the arbitral tribunal in the conduct of their arbitration proceeding. On the flip side, if you look at the ad hoc arbitration, in which there is no institution, there are just parties. They have to cooperate with each other with respect to the appointment of the arbitrator, or to set a date for hearing and all that, right? And in international arbitration, ad hoc arbitration is not preferable, because what if the other party is not cooperating, then you cannot do much in that case, right? But in institutional arbitration, if the opposing party or your counterparty is not cooperating, then you can go ahead with the ex parte proceeding, right, and get that award. But in ad hoc arbitration, it would be very difficult to come to the conclusion if the other party is not agreeing to sit and resolve the dispute. And now, after discussing the elements of an arbitration and the reason why someone should go for international arbitration, here comes the definition for international commercial arbitration, again from the Garipon book. It states, and I quote, a process by which parties consensually submit a dispute. And you will look, I mean, bold and highlighted those parts that we discuss as an element of the arbitration, right? Consensually submit a dispute to a non-governmental decision maker, which is a private person, neutral third party, selected by or for the parties, to render a binding decision resolving a dispute in accordance with the neutral adjudicatory procedure, affording the parties an opportunity to be heard. I hope it's clear. Then there are certain core features of international commercial arbitration, that the parties, there should be two private parties involved, then that arbitration would be considered as a commercial arbitration. And there is the state can also, state entity can also be part of the commercial arbitration if that is appearing as a business entity or for the profit making enterprise, right? In that case, that would be considered commercial as well. And then it a consent-based jurisdiction, of course, arbitration clause as cornerstone of arbitration. And I also used to confuse between what is the difference between arbitration clause and arbitration agreement. And I think there is no analytic these two terms, but there is a clear difference. When parties are drafting a contract, and if they include a dispute a resolution clause, or if they choose an arbitration to resolve the dispute, then it would be termed as an arbitration clause because it become part of their parent contract. But let's say if parties, they have drafted a contract, and after that a dispute arises, and now they were like, we want to resolve a dispute through arbitration, right? Then they will have a separate arbitration agreement that will list down all the details necessary, right? And then party autonomy, one of the major or important concept of arbitration, that parties are given the freedom to choose a substantive law. And this does not actually happen in the national court system, right? The judge will not ask you like which law I should apply, or which procedure I should be following, right? So this is one of the reason parties should opt for arbitration. And then also they can choose for the procedural law, and then they can choose the arbitrator and the institutions as well. And then the last point is that it's neutral, it's binding and enforceable. What I think we have already discussed in previous slides. Okay, so as I said, arbitration agreement is the cornerstone of arbitration, and the parties should be very careful when they are drafting an arbitration clause, right? There are certain core elements that must be present in an arbitration agreement, and then there are other elements which are actually implied, because if you are choosing arbitration, of course, it's a confidential mean of dispute resolution. But if you want to make sure that confidentiality should be protected, then you can include, of course, right? So first of the element is agreement to arbitrate. So the wording of your arbitration clause or arbitration agreement should say that the dispute will be resolved and should be resolved by the arbitration. And if any arbitration clause state that any dispute arise out of this contract may be resolved through arbitration or litigation, that's not a a proper or valid arbitration clause, right? What if one party go for the litigation and other wants to do arbitration? Then you have a conflict. So that's why the wording of your arbitration clause should suggest that there is only one mean of resolving this specific dispute, and that should be arbitration, right? And then the party should, highlight that where they want to go institutional arbitration. By that, you can specifically mention the arbitration institution, and as Matthew mentioned, different institutions like we have London Court of International Arbitration, International Chamber of Commerce, Permanent Court of Arbitration, and all that, right? All those institutions. Then choice of arbitration institution, governing law, and this is very crucial aspect of the arbitration clause, because in most of the Wismut problem, and I think I have experienced like three of the Wismut, and every time there is a conflict with respect to the governing law. So majorly and many parties, the part law will be governing the substantive part of the contract, right? The parent contract, but they does not specify which law should arbitration. And there is a very big debate on this, like whether the law of the seat of arbitration will be applicable, or whether the law of the parent contract would be applicable, right? So you should be very careful when mentioning which law should be applicable on the contract and then on the arbitration proceeding. And then place of arbitration, scope of arbitration agreement, and by that we mean whether you want to resolve all the disputes through arbitration or certain disputes through arbitration. And then you can also select number, method of selection or qualification of arbitrations, right? And then language is very important. You cannot, title, any African language for a party who has a background from Australia and United States, right? So you need to choose a language which both parties are feasible. And for example, if two parties are from Africa, then you should not entitled to choose English as a language of the arbitration, right? You can choose the language which both parties are comfortable communicating, right? The other element could be confidentiality. And as I said earlier, it's an implied thing because arbitration is, of course, confidential. Allocation of cost of legal representation, if you are worried about your expenses, interest and currency of an award. If you are from a developing country, then I think you should go for a currency which is going to, of some value at a later stage, and then disclosure of the discovery, whether you want to opt for the fast track or not. And in certain arbitration clauses, I have seen the parties willfully excluded fast track arbitration proceeding. So it's totally depends on the parties whether they want to opt for it or not, right? And then the multi-tier dispute resolution clause. And I really suggest that any party, if they want to include a dispute resolution clause, that should be a multi-tier dispute resolution clause, because most of the time, if the parties can sit together and discuss their dispute, it's highly likely that the dispute will get resolved, right? Instead of going to the arbitration and spending a lot of money, right? And one of the fear that party used to have before the Singapore Mediation Convention was that the mediated agreement is not enforceable. But now that problem is resolved, and Pakistan has also become signatory of the Singapore Mediation Convention. And I think this is a very good development in Pakistan. So parties should, at least utilize, because there are not much cost or even time spent during the mediation proceedings. So parties should at least try before going to into a very expensive process. Very quickly going into international investment arbitration, it's a bit different from the international commercial arbitration, because in that arbitration you have two private parties. But in investment arbitration, on the one side, you have a private party, which is an investor, while on the other side, you have a country, a host country, in which that investor is bringing that foreign investment, right? If we can read this definition, investor-state dispute settlement allows an investor from one country to bring arbitration proceeding directly against the state in which it has invested under international treaties. And by international treaties, we does not mean a United Nations Charter or anything like that, right? We mean bilateral investment treaty, multilateral investment treaty, or regional investment treaties, right? And those treaties are there to protect the foreign investments as well as foreign investor, because at one side you have a private party, on the other side it's a whole sovereign state. So there should be a protection provided for the investor from any bullying. So the key features included, again, on one investor, on the other side you have a host state. A legal basis in investment treaties, as I said, bilateral investment treaty, multilateral, and is that they two are both the actually first bilateral investment treaty in 1956. So they actually started this trend of investment arbitration. And then grounds for claim expropriation, fair and equitable treatment, full protection and security and national treatment of that. I think I'm short on time, so I will just quickly go over it. The institutions are different from where you can bring your commercial disputes. In that case, you can bring it to exit tribunal, which work under the World Bank, and it's in Washington, D.C. And then we have UNCITRAL. These are just the rules. This is not an institution. So if the parties have chosen in UNCITRAL rules, so they will be handling or managing all their proceedings, but of course they will be following those rules during that. And then we have Permanent Court of Arbitration. This court deals with both commercial arbitration disputes as well as investment arbitration dispute. And again, these awards are binding and enforceable. And one of the landmark example of this is Rekodi case. And I think not only from Pakistan, but from other jurisdiction as well, people will be aware that because it was against the policy of the government at that time that we actually didn't enforce that award. And then again, international arbitration does not actually shut down if the host state does not enforce that award or did not enforce that award, right? Then that party can go to any other jurisdiction which has signed this ICSID convention and the New York Convention, right? And then they can get or compensate that award from that. And in this case as well, in Rekodi case, the Pakistani Supreme Court says that we are not going to enforce that award. They were like, very enough. Then they went to the British Virginia Island, right, where they enforced that award, and they were also, I think, Pakistan International Hotel was there, and they were trying to sell it, but then of course it get resolved, and they actually used this award as a leverage to renegotiate the new contract with Pakistan, and I think they are working on it now. A quick difference between international commercial and investment arbitration. I think we have already discussed, but a very quick difference. It involves two private party, on the other side, private and sovereign state. This is based on a contract between the parties, and in that contract, we have an arbitration clause which provide foundation for this international commercial arbitration. While on the other side, we have bilateral investment treaties or the investment laws as well, right? In these, you have different institution. For the investment, you have different, but there are some common institution as well, because one of the problem why this institution does not take up investment arbitration, because in commercial arbitration you have two parties, you don't really have any money of the public at stake, right? But in investment arbitration, you, if this arbitration is being done by a private person, then what about the, I mean, rights of the citizen, because it involves their money, right, their taxpayer money. So that's why we don't really see any growth in the institution. But I think there is a lot of discussion with respect to the formation of an international investment court or something like that to actually nullify that argument. And then applicable, of course, at the investment treaty, that is the main law that is applicable. And then we will also be using the treaty standards as well, right? And then the public trade, it's purely commercial. While on the other side, it involves state regulation. It can be health regulation, environment. For example, if the investor is doing something that is very, I mean, dangerous to the environment or any species, then of course the sovereign state can put some regulation on the activity of the investor, right? And I think that's all from my side. And if there are any question, I think Matthew and I would be love to answer those.
Sorry, can I ask?
Yeah, sure. Please go ahead.
So as you mentioned, my question dedicated to New York Convention. So in Article 2, as I know, it has provision which dedicated to like enforcement of an arbitral awards, which might be refused in the situation when arbitral awards would be contrary to the public policy of that country. Therefore, I want to ask, like, have you like faced a situation where a public policy was cited as a reason to resist enforcement? And how did you?
Yeah. Yeah, I think in addition to Article 2, I think if you may be referring to Article 5, subclause 2, that present public policy as one of the ground for to set aside an award. And I mean, freely speaking, this ground has been taken in almost all the enforcement proceeding. Even if they have, I mean, a good reason or not, they always use this public policy ground to set aside that award. And one of the landmark example of this is the Rekodi case, in which Pakistani Supreme Court state that because it is against the public policy of that country, so that's why we are not going to enforce that. And the public policy is a very, I would say, a broad term in which you can include state regulation, you can include court orders or executive orders, prime minister order, president order, all that, right? And in that Rekodi case, even Balochistan government, which is one of the province of Pakistan, tried to revoke that contract. Then Supreme Court also state that as we have already given a decision, we are not going to accept a parallel proceeding, which is arbitration. It should have been other way around, but of course, when you have to set aside that word, you have to use that public policy ground. I hope I answer your question. Okay, I think next, Sayed.
Sir, can I ask a question?
Yeah, sure, Afan. Go ahead.
Sir, I hope you are doing well.
Yeah,
Sir,
I'm
my
doing.
question is related to the ongoing disputes, as we have just wrote about the mediation. So I'm going to ask that which international organization or neutral platform, such as the International Criminal Court (ICC), the United Nations, or regional actor, could most effectively take the lead in mediating the ongoing disputes between the Iran and Israel or America, the Palestine and Israel, as what makes the platform suitable for such a sensitive and high-stake diplomatic effort?
Okay, so Afan, your question is relevant to the current affairs, but it's not relevant to this number, of course, because it deals with the international business transaction, right? But I will give you the answer. And I forget that person who actually uses that quotation. It states that international law is in the air or nowhere. So international law does not have that kind of enforcement capabilities or mechanism to enforce the decisions, right? I mean, ICJ or the other courts have done a lot of stuff, and I'm not going to name anyone. So I think between the sovereign state, they have an option to go for an arbitration, which we are discussing right now. But of course, it is with the consent of the parties. Even if you look at the Indus Water Treaty, it states that if any dispute arises, that would be resolved by the arbitration. And arbitration is being a consensual mean of dispute resolution, right? But Pakistan is not actually pressurizing the World Bank to issue an ex parte award, right? They can do that, but they don't want to do it because if they issue an ex parte award, then Pakistan cannot enforce it. Of course, India is going to say, I haven't given the opportunity, I don't want to do that, right? Then it will nullify the effect of the treaty itself. So just to protect its essence, we are not going into that direction as well. And the other dispute, I think we can left that into the public international law arena, United Nations Security Council and all the entities are there. And one of, I think, the major factor that can resolve the dispute is power. The country which is powerful, they can actually push other countries to, I mean, favor that international law, right, to protect the other country. And I think we can now take question from Syed Abdullah Anwar.
Hello, sir, can you hear me?
Yes, I can hear you loud and clear.
Thank you. I just had a small question that if there is an arbitral clause which does not specify the lex arbitri, in that case, will the seat of arbitration determine the
Could you
lex
please,
arbitri?
I'm sorry, I just got a call, so connection was.
Please, please. Shall I repeat my question again?
Yes, please. Yes.
Okay. So, in case that we have an arbitral clause in which the lex arbitri is not specified, does in that case the seat of arbitration determine the lex arbitri, or can the parties determine another lex arbitri in that case?
Okay, as I said, like in most of other, I mean, recognized discussion like common law versus civil law or reality versus, I mean, a lot of these major discussions, right? Similarly, in arbitration as well, we have this discussion that in case parties does not specify the law that will govern the procedural aspect of the arbitration, right? Which law should be applicable? We have different case laws as well, but of course in arbitration those are not binding; those are persuasive. But there are certain standards that we can use. The closest connection test, in which you will look at like whether the parties were trying to refer that the contract clause should be applicable. For example, if parties chosen Kazakhstan law as the governing law of the contract, then we can infer from that they also want to apply that Kazakh law on the procedural aspect as well, right? On the proceeding. But on the contrary side, they say no, we are not going to go for that, right? They say if the parties have specified a place, let's say they have specified Uzbekistan as a place